We are ready with our sixth session, and this session will focus on Brexit and changes in dispute resolution. The moderator for this session is Rotimi Sani. He's the partner at Rotimi Sani and Co., Nigeria. The speakers for this session are Johannes Quep. He's the partner at Baker Botts LLP, UK. And we have Daniel Levy. He's the counsel at Enyo Law LLP, UK. So now I will hand over this session to Rotimi. Thank you.
Good morning, everybody. I hope we had a very peaceful night and good rest. We are moving to the second, today is the second day of this program. Yesterday, we looked at about 5 different topics from our distinguished speakers. Today, we'll be looking at the 6th session, which is Brexit, changes in, excuse me, we'll be looking at changes in dispute resolution. As our distinguished speakers, we have Johannes Kep and Daniel Levy. I will not take too much time talking about them, but they are very distinguished speakers, both counsel and arbitrators. And I will first of all call on Daniel Levy. Daniel Levy will be looking at disruption, the unpredictability of a post-Brexit dispute resolution scenario, and the role of English law and English case law as a post-Brexit savior. We'll also touch on the competition of Paris and other jurisdictions to London as London's special place in dispute resolution. And we'll also touch on recognition of foreign judgments after Brexit. If there is time, we'll touch on the resurrection of anti-suit injunctions. We'll all be free to contribute because this is a very important and very interesting topic. Brexit, Europe, generally, as we all know, is the biggest economic bloc as well as the most influential cultural bloc. And so whatever happens here is everybody's business. So I will call on a very good friend, Daniel Levy, to open there.
Well, thank you. Good morning. First of all, thank you very much to me. It's really a pleasure. Thank you to be here. I'd like to thank the organizers. It's a very honored invitation to be speaking a little bit about Brexit and especially about dispute resolution, which is what I do. I am originally from Switzerland, and I have been living for 20 years in Brazil now, because my wife is Brazilian. And so I think I can, what I'm gonna try to do here is try to bring now as an English lawyer and as working in an English firm, is not only a Brexit perspective, but also an outsider Brexit perspective of what I've been looking at in the main discussions for our futures as dispute resolution lawyers. So Basically, my presentation will be very quick. It will be something very introductory and under a much more macroscopic approach in order to try to bring the openness on the political views which I have been looking at lately on what are the government's plans to dispute resolution in London, so that my colleague Joanne can then go a little bit deeper into international arbitration and on some more technical questions which are extremely important. So I will basically try to go through those 4 important points. The one, just to look at, at the end of the day, we know nothing. This is unpredictability. The role of English law and English jurisdictions as what I could say one of the big saviors of London as a hub for dispute resolution. The stability of our courts and the stability of corporate law in the UK as another savior of London. And finally, I will try to look a little bit on the competition of different cities around the world which are taking advantage of this moment to try to develop their own dispute resolution hubs. And if you've been to the Paris Arbitration Week, and after the Fashion Week, now this is this most important week in the Parisian calendar, is the Paris Arbitration Week. Last 2 months ago, there were almost 5,000 to 4,000 lawyers in the opening cocktail. So they are making a little much effort, and we'll see how they're doing it apart from serving good champagne. So my first point is like Socrates always said, all we know is that we know nothing. And I don't think I'm alone. I think Ms. Theresa May, if you have read the newspapers this morning, is quite embarrassed to say she is not sure what's going to happen either. So I think if we look at the solution of the dispute resolution scene, there is no solution, there is no one-size-fits-all solution for what we will become in terms of cooperation with other EU countries after Brexit. A very interesting report of the House of Lords was published on May 3rd, 2018 this year. It's public, you can just Google it. It's a 52-page report of the EU Dispute Resolution Committee, which analyzes what are the main issues, the main concerns for, and especially which are the main proposals to improve London as a dispute resolution hub after Brexit. So, of course, I don't have the time to go through all the suggestions, although the report is really good, it's really interesting. I really recommend that you read it. But I will very quickly go through some of the solutions here. So, a first proposal of the House of Lords on this report to have like a dispute resolution solver or a dispute resolution court to EU-UK disputes would be to dock with the EFTA court. I think they make the suggestion, but they quickly know this is not really possible because the EFTA court has a very different jurisdictional frame and would not really be able, unless there is changes in their bylaws and statutes, but they will not be able to analyze disputes arising out of a withdrawal bill. They are much more focused on economic and would have to have an upscale, an improvement for the volume of questions that would arise from commercial matters, including UK-EU disputes after Brexit. So that's a first idea, not really realistic, but it is very interesting as the English, they do very well. It's put there to analyze and to allow us here, for example, to discuss it. And I'm absolutely happy to discuss this afterwards. A second one would be, why don't we create an UK-only court, which would be the one analyzing disputes arising out of the UK-EU scenario? But as the report also saying, that's why I really love the way the British write those things. Well, that would be, and these are just their words, making its own homework, and that's true. How an UK court would be neutral enough to analyze UK-EU disputes, and this is the same problem for the European Court of Justice today. The British say it's not really neutral to analyze UK-EU disputes. So the third option would be an arbitration agreement in the withdrawal bill, and arbitration as a whole, arbitration as a general solution for EU UK disputes or any commercial disputes arising with EU UK law questions. And first of all, then we have the problem that arbitration would not be suitable for any more political or even public undisposable rights, okay, only for strictly commercial or trade questions. And most importantly, in view of the recent Achmea case in the European Court of Justice, it's much likely that even if there was an arbitration agreement treating which the scope would be EU-UK law, even though it's most probably there will be much instability because the European Court would say, I am the only one who could really analyze European law. I have my criticisms on the Achmea decision, as many have, but I would say this is not a very stable solution in view of this recent case law. So any disputes, even commercial disputes, not only BIT disputes, but maybe even disputes arising of two individuals under absolutely private contract, but that would touch European law or that would touch the withdrawal bill agreement if there is one. Even though I'm not sure the European Court of Justice would be absolutely happy not to be referred. So we have to look at what's gonna be, so to be continued. But this is not the worst solution. A joint court, okay, which would of course not be the Court for European Justice, and then we have first a budget problem here, and especially this is an idea which was already rejected in 1991 when there was the idea to establish an EEA EU court, especially an idea which was brought forward by Switzerland. And it did not really work, so why would it work here? And we are not in a very budget-pro moment, so it would cost money. Swiss-style bilateral treaties. It's interesting because another very interesting thing the report puts forward, because they know it will never work, but still they put as one of the solutions. They know it will not work because the European Union is right now trying to reorganize all its bilateral treaties with Switzerland, which makes an absolute jangle of thousands of BITs and thousands of different interpretations for different facts and matters of law. So it's a solution, it's a proposal brought by the report, but which will certainly not be put forward afterwards. And then why not use the WTO? And this is the same problem for the EFTA court. We could use the WTO to resolve UK disputes on the withdrawal bill. However, as you all know, the WTO would be restricted to only trade matters. So all the political ones, family matters, child abduction matters, etc., would not be included, of course, in the WTO. So at the end of the day, the report is very interesting because it brings all the solutions, but it does not really choose one. It maybe says an arbitration agreement or even having a joint court may be one solution. So the joint court, I would say, would be between the worst solution, the less worse, and then why not an arbitration agreement within the withdrawal bill? But well, everything is to, we are living history. So as we live history, it's very difficult to present something on it. A specific point here, just to say, the CGEU is not an option. Okay, it's not an option because the European Union, Mr. Barnier, they don't see this court as a neutral court. I have my doubts, but yeah, it's the European court. It's not the UK court. It's not the UK EU court. It's the European court. So they are thinking about it because it would be the easiest solution, because it's already established, it's already funded, it already has a very strong presidential history. But yeah, of course, it's the court of one of the parties, so it would have certainly some conflict. But it's something that I see when you read the report, that it borders the House of Lords, that it is such an important such an important court established, and that could not be used. And the proof of that is that one of the members, or two members of the task force of the House of Lords report, are members of the CGEU. So it shows the importance of that court and the history it has. So let's see. I don't think it's the worst solution, but I'm not gonna really position myself now. So the idea would be, after Brexit, the CGEU would not be used as the resolution dispute hub for these questions, but we could use its influence, and specifically there would be the idea of having its more historical cases binding as Supreme Court precedents. Okay, so that's something the UK would be willing to do. In terms of governing law and jurisdiction, very quickly, I think this is one of the saviors of English law. We have a very, very strong jurisdiction. We have a very strong law. And I think people all around the world, companies knows that. Today, the UK encompasses the UK legislation, of course, Brussels 1, Brussels 2, Rome 1, Rome 2. So the Comcast, the contractual, non-contractual disputes. So after Brexit, there is a willing from MPs, from the government and from the UK negotiators to incorporate into English law many of the disposition on the Rome's regulations. The withdrawal bill, to the extent of possible, would try to continue to apply to new contracts after Brexit, at least all the principles of Rome 1, Rome 2, which are very good principles, although much more civil law principles, but which we've been applying under a common law approach for quite a long time. So, in terms of jurisdiction, of course, I think here we could have more problems, because at the end of the day, we can criticize the EU, we can criticize the jurisdiction corporation, but it's true that the Brussels regime, the Comcast, helped a lot the dispute lawyers around Europe. We didn't need to serve claims in other countries through enforcement procedures, and for example, I come from a country these last 10 years where in Brazil, for example, it could take 2.5 years just to enforce one judgment. So sometimes we think it's bad, but we haven't seen worse. So that would be something interesting. There is no here, I think, contrary to governing law, where the British government is much more willing to incorporate some of the EU standards, here, in terms of jurisdiction, there is much more doubt. So there's a couple of options what to do in terms of jurisdictional cooperation with the EU after Brexit. So would we be just willing to have a specific arrangement on some cooperation, so what we call in international private law dépeçage, which we would choose which kind of cooperations in Brussels we'd like to do. The Lugano Convention, like Switzerland, the Brussels, the Hague Convention on enforcement. So this will still be something to do. What I think, and what I am, I as an international arbitration practitioner today, much more than dispute litigation practitioner, my main concern would be the return of torpedoes. We've combated them, West tankers, etc., etc., etc. UK would maybe have to tackle them again. UK would be a very interesting forum to start litigation. However, we've been seeing this, I'm not gonna enter into one part, but we've seen a very good case law these last weeks and months very good to arbitration in England. So that's a very positive effect of Brexit, I think. So the judges are each time more conscious that they have to protect arbitration in London. But I think the torpedoes, so the anti-suit injunctions and etc., would be a concern. In terms of stability, just before my last point, I don't need to tell you, I think you all know how English corporate law is important. I have clients today. I have, for example, an arbitration between a Peruvian company against a Chinese company which is seated in London with English law applied. So you see, absolute no link with England apart for the use of English law because they like it. So English law, I think, would be for us lawyers one of the benchmarks, one of the best ways to still sell London and the UK as a very good hub for dispute resolution. We have extremely, not to say the best, but extremely well trained lawyers for very, very complex commercial matters in London courts, which I was amazed when I went to my first trial here, and it could take like 6 weeks. And you know, a Brazilian judge would maybe be with you for 10 minutes so you can explain the case. And so all this familiarity and all this proactivity towards complex commercial matters is very important, and parties knows that, and parties, most importantly, are willing to pay that because it's quite expensive. So I'm not gonna go through it. I can send my PPTs to you, but if we look at the M&A laws and regulations, most of them will be incorporated and are already very much influenced by the UK law, by the UK system. So there will not be many changes, but of course, for all the M&As or cross-border mergers, of course, there will be to have some small adaptations, which will not cause a problem. I think the problem will be much more after that for the disputes, but for the preventive part, which is here, I don't see really, I'm not really concerned. What we have to wait and see is which model of Brexit, and again, there was this morning again, Theresa May fighting the Commons, so we don't know. We have to wait and see which model of Brexit we'll have, because if we have a Norwegian model, the solution will be much more pro-EU. If we have a Swiss model, we can have a much more independent and autonomous legislations on it without needing to follow EU standards. But I think in terms of international trade and the threat today to have a truly international M&A and corporate world, specifically because we are living in a very, very pro-M&A times this last month with all the M&As you've been reading in the newspapers, it would be quite a shame not to follow these more cross-borders rules coming from the EU with the caveats that the UK government would like to do, but I think it would be really good. Finally, I just wanted to alert all of us for the competition coming from different cities on the wake of Brexit. So I think the most significant one is Paris. So Paris and Emmanuel Macron is absolutely conscious that this is his time to make Paris a dispute resolution hub. And this is not me saying it. This is in his official government points. And he's been a true supporter of Paris as place d'arbitrage. They have just established the International Chamber of the Court of Appeal of Paris. So this is for French, and you know, I was born in France, so I can say some things about the French. And for the French to establish an English-speaking court, it's quite a step. So they have established this court, which is not, that's very important, which is not an autonomous jurisdiction clause chosen court. It's an appeal court for international commercial matters. And in this court, you can, of course, have hearings in English with, of course, translations to French or vice versa. All judges are familiar with corporate law, with commercial matters, and most importantly, in France, they speak English very well. And I know a couple of them because we had one session of the Paris Arbitration Week where I was sitting with one of those judges, and he's truly amazing. He has a very strong common law background. And that's very funny. That's why we see there a very important common law influence in this court. So the appeals on those international commercial matters will be reverted to that specific court. Three main points. So the jurisdictions, as I said, they can hear anything on international business disputes. So the language, you can plead in English. The submissions can be in English, but in this case, they must be translated into French. That's the only concession they did not make. So the submissions must be in French, but they can also be, they will probably be translated. However, the documents can be in English, which for us lawyers is very important because there's a root cost of translating documents. And so all documents does not need to be translated into French. As I said, the hearing can be in English, but then again, they have to have a French interpreter. Very interesting. They adopt some very, very common law procedures like cross. So we can cross-examine. We don't need to ask the judge to ask the witness. We can have a direct cross. We can have a recross. We can have a much more arbitration-like procedure in this court. So it's not working 100% yet, so we have to see how it goes. And if you read the rules of that court, which are also on Google, you can find them. It's confessed common law model, and it's confessed BREXIT combative. So you read, considering BREXIT, we would like to suggest that. So just to conclude, I think I'm a little bit worried, as I think maybe many people are, on the slow pace of negotiations, and if the negotiations are quite slow in terms of trades and in terms of nationality, and in terms of hard border with Ireland, only God knows when we'll have a true dispute resolution agreement. However, this is very bad for clients. I think what I've been seeing are Brexit hardship clauses. So clauses, each time more I find in contracts clauses saying that whatever the decision will be in terms of jurisdictions, the parties, any of the parties are allowed to review them. So I can change my forum, the seat of the arbitration, the seat of the litigation, etc. This is good for international arbitration, already introducing Johannes, but I think this will be an extremely good opportunity to the growth of arbitration in the UK. And I've seen today Latin America, which is one of my specific niches. I have seen, for example, Mexico, today, Pemex, which is the biggest oil company, the Energy Commission in Mexico, all of them are adopting by standard LCIA clauses. So in the maturation period until we have a dispute, which is like 4, 5, 6 years maybe, it is quite probable that we're gonna be a rise on dispute resolutions in the LCIA. So, for example, Latin America is a very good place to look at. The Chinese also, very common. They've been looking at London with very good eyes. We have had some cases involving Chinese investments in Africa, which are mining, oil, and the same for Latin America, with a specific here mention to Peru. All those Chinese contracts have London as a seat and English law, most of them, of course. And this is another market which I think would be very interesting. At the end of the day, London will be a much open market. So I'm quite confident that we will have a very strong dispute resolution hub, maybe even better, because Brexit is a wake-up call for better and stronger dispute resolution rules. At the end of the day, my only concern is the unpredictability, because today everyone who does dispute resolution knows that the ratio of a client, of a company, is not anymore win or lose, is how much it will cost. And they need to make provisions. They have to show their board the budget. And not knowing what will happen is much worse, in my opinion, than losing a case. So of course, while I want to win, but today what I would like to offer my client is, first of all, an assessment of risks, which we cannot do today because of all this unpredictability. Thank you very much.
Thank you very much, Daniel. Let me apologize for a little bit of incoherence that I imposed on the House. Next, we'll move on to Johannes Kep. Johannes Kep will speak on, we will examine London as a seat of international arbitration post-Brexit, as well as look at the UK and intra-EU bilateral investment treaties post-Brexit. Thank you very much.
Thank you very much. Thanks also to Daniel for this excellent tour de force. The way we divided this up was for Daniel to first give this general overview, and for me then to address two specific areas that I'm very familiar with, international commercial arbitration and the future of treaty arbitration post-Brexit. So let me start with the future of international arbitration. I don't think that. Here we go. The future of London as a seat of international arbitration post-Brexit. Most commentators agree that the future of London as a seat of international arbitration will not be hugely impacted by Brexit. And the reason for that are listed here on the current slide. The main reasons for the success of London as a seat of international arbitration remain largely the same. The first three points are what I call the objective legal framework. So the first item, the English Arbitration Act 1996, is the law, of course, that applies to international arbitrations seated in England. And there will not be any changes to that law as a result of Brexit. Prior to Brexit, there was some talk about certain amendments to be made to that act. And since the referendum vote, these discussions have kind of lost importance, because now there are more important things to be considered. So these amendments are likely to be postponed, but the framework as such remains unaffected. The second important factor for any seat of international arbitration is, of course, that the jurisdiction is a signatory to the New York Convention. And again, the UK's decision to leave the European Union will not change anything in this regard. Thirdly, users of international arbitration look to the judiciary at the seat of the arbitration and assess whether that judiciary is arbitration friendly. And by that I mean, is the judiciary quick, for example, to annul arbitral awards made in that jurisdiction, or is the judiciary quick to interfere with pending arbitration proceedings? And in England, as Daniel has already mentioned, including in recent months, there's a huge body of case law that illustrates an extremely pro-arbitration stance of the English judiciary, which is one of the factors why parties are so comfortable with choosing London or England in general as a seat of international arbitration. I forgot to mention that London is actually the most popular seat of international arbitration. There was a recent survey of the Queen Mary University and White and Case that showed that 64% of the users chose London as their most preferred seat for international arbitration. So I think this is testament to the attraction that London has in this sphere. Fourthly, London has an incredible arbitration infrastructure. And by that I mean, for example, the facilities on Fleet Street, the ICDR, excellent hearing rooms, all of the hotels in London that are always happy to host international arbitrations. Perhaps even more importantly than the physical facilities is the London Arbitration Bar, both the commercial bar, so whether it's Essex Court, Fountain Court chambers or other excellent chambers, the quality of the English barristers in the field of international arbitration is second to none. And then there are, of course, hundreds of solicitor firms that specialize or say to specialize in international arbitration, and the offering is very impressive indeed. And then, of course, translators, document services, asset tracers, etc. So the infrastructure here in London is very impressive. Fifthly, the English nature of international arbitration is also unlikely to be affected by Brexit. By that I mean that international arbitration seated in England is more marked by the characteristics of the English judicial system and English litigation than, say, a Swiss-seated arbitration is by the characteristics of Swiss litigation, or a Swedish arbitration by the characteristics of Swedish litigation. There's a particular flavor to an English arbitration. One of the reasons is that oftentimes if you have an English-seated arbitration, you end up with 3 QCs on the bench. And these QCs normally spend 50% or more of their time in the English courts and are then also more likely to adopt procedures in international arbitration proceedings that are more akin to English court procedures than what you would normally find in an international arbitration. And therefore, for you as an international lawyer, an English-seated arbitration is perhaps more difficult a nut to crack than, say, an ICC arbitration seated in Geneva, because it is oftentimes very, very English in nature. Sophisticated users of international arbitration actually know and appreciate that, and therefore choose London as a seat of international arbitration. Again, a reason that is unlikely to be affected by Brexit, perhaps even to the contrary, if one considers Brexit as an expression of a certain English sense of superiority. I would even expect the Englishness of international arbitration seated in London to be more expressed than previously. Sixthly, the enforcement of English arbitral awards made in England, of course, will still be subject to the New York Convention, and nothing will change in this regard either. Some changes brought about by Brexit will actually even strengthen London as a seat of international arbitration. And in this regard, Daniel already alluded to the possibility that English courts post-Brexit will be able to issue anti-suit injunctions in support of English arbitrations in relation to parallel court proceedings brought in other EU member states. So this is a special jurisdiction of the English courts that arises in circumstances where parallel court proceedings are brought in purported violation of the agreement to arbitrate, and the English courts then assume the power to tell the party that purportedly acted in violation of the agreement to arbitrate to stop suing the counterpart in a different jurisdiction. Some years ago in the West Anchor case that Daniel mentioned, the European Court of Justice said that this is incompatible with the spirit underlying the BREXIT regime, i.e. the spirit of mutual trust between the courts of EU member states, meaning that it is not right for one court in the European Union to tell another court not to hear a certain case, but the court that first sees should always determine its own jurisdiction. And therefore, within the sphere of the European Union, at this point, the English courts are unable or not allowed under European law to issue such anti-suit injunctions in support of English-seated arbitrations. They still do so, however, in relation to court proceedings brought outside the European Union. So, for example, if you have an English-seated arbitration involving an Indian party, the Indian party brings parallel court proceedings in India, then you as the other party could still go to the English court and ask the English court to issue an anti-suit injunction ordering the Indian party to refrain from bringing these parallel court proceedings in India. Now, the hope of some arbitration lawyers is that post-Brexit, once the English judiciary is freed of the fetters of European law, it will again be able to issue such injunctions also in relation to parallel court proceedings in the European Union. Whether or not this is possible will depend on the regime that ultimately is adopted in the sphere of recognition and jurisdiction and recognition and enforcement. Daniel has already said that there are various options that are being discussed, at least among academics. I'm not so sure whether the politicians have really focused on this point, although it's really an important one, but I don't think there's a clear policy position on the part of the UK government yet. So one of the scenarios, and perhaps the most likely scenario, is that the UK will become a member or a signatory to the Lugano Convention. And under that convention, it's also open to doubt whether such anti-suit injunctions are permissible or not. So
then there's going to be the question: who's going to decide that issue?
Exactly. Yeah. So under the Lugano Convention, the ECJ has no jurisdiction over UK courts, but UK courts are still obliged to take the decisions of the ECJ into consideration, which is one of the reasons why I'm sure Brexiteers will not be too thrilled with the idea of the UK becoming a member to the Lugano Convention. But yeah, we shall see what's going to happen. Some changes may be for the worse. The uncertainty, of course, has been mentioned already. There are some doubts as to what's going to happen to freedom of movement. Will, for example, a European lawyer need a visa if she wants to arbitrate here in London? Challenges abound. Paris, of course, is a fierce competitor and very hopeful to get a greater share of this arbitration pie. Switzerland is a strong competitor. Singapore is getting stronger and stronger, and everyone wants to have a part of this, of the London business. More than 5,000. I recently read that more than 5,000 international or arbitrations are initiated every year in London, which of course is a very impressive number. Another threat to London as a seat of international arbitrations are sanctions. We've seen this in our transactional work involving Russian parties, that Russian parties in particular used to choose English law and English courts or English law and RCA arbitration almost by way of boilerplate. And because of the sanctions, there's now a certain, and also because of tensions between the UK and Russia in general, I think there's now a certain reluctance on the part of Russian parties to continue to do that. So we've seen a lot of SIAC arbitration clause, and while we have actually still a steady flow of Russia-related arbitration work, I think it is a question of time when these arbitration clauses providing for alternative fora will materialize, and more of this work will end up in other fora, which for the English arbitration may not be a disaster, because much of the Singapore and Hong Kong seated arbitration work is still done by London arbitration law. And the last point here on this slide is, not so much a legal than a psychological point. Given that Brexit is a kind of divorce, it may also, and depending on how this separation actually ends up, whether it's an amicable divorce or whether everything will become very acrimonious at the end, there's also a risk that some European parties will no longer consider London as a friendly or at least neutral jurisdiction, but will be more reluctant, therefore, to choose London as a seat of international arbitration, and may then use the uncertainties created by Brexit as a pretext to insist upon another forum. Now, this is the theory. I already mentioned the survey of Queen Mary University and White and Case, which asked users what they thought Brexit may mean for the future of international arbitration in London. And at least I was surprised that 37%, so almost half of the respondents, answered that they think it will negatively affect London as a seat of international arbitration. Although, as we've seen on my previous slide, objectively, there's actually very little reason for this risk to materialize. But 40% of the respondents are of that view. Now, to what extent this is kind of wishful thinking is another question, because I suppose many of the respondents are at least secretly hopeful to get a part of this business. And the fact that the same survey actually showed that London is, by a distance, actually the most popular seat among arbitration users also suggests that perhaps the strongest human sentiment, jealousy, may have been a driver between some of these answers. 56, so the majority believes there will not be any impact at all, and a small majority of, I think, I don't wear my glasses, I think it was 9%, yeah, of 9% thinks that there's even a positive impact. And this may have to do with the possibility of anti-suit injunctions or the Achmea judgment or other points. Now, this is clearly too small, even without my glasses. I will tell you what's on this. I know, it's the same. So something went wrong there. I will quickly read you here what's on this slide, because it's also rather small. So the first 3 points, the question was, what are the principal reasons for your answer? And the answer was on the previous slide. And the first 3 slides, I think, illustrate very well why most of the respondents think there will not be any change, or if any change, it will be positive. So 40% of our respondents said that the English legal system will continue to be perceived as neutral and impartial. Equally, 40% said the legislative framework applicable to arbitration and the English courts will continue to be supportive of arbitration. And thirdly, the UK will continue to be a party to the New York Convention. And if you remember my first slide, this is exactly what I called here the objective legal framework. I had it here in a different order before seeing the answers of the respondents, but I think these are really the 3 main factors that are so important to London as a successful seat of international arbitration. The factors 4, 5, and 6 here, then in contrast, support the view that the change will be negative. There are uncertainties over the impact of Brexit on English law and the English legal system, 27% of that view. Other arbitral seats will appear more attractive by comparison, 25%, and thirdly, London's reputation as a commercial center will diminish, 25%. In my personal view, the last part is actually a concern of mine, at least, because I think at least in 10 years or so, for young, talented lawyers, I think London has now become a less attractive place to start their legal careers than it was when I was young. So my worry is that a talented lawyer who can now choose between London, Paris, and Geneva is less likely to choose London in light of the Brexit vote. Sorry, I don't know. Technically very able. Okay. Now this is this slide purported to answer the question. What forum is likely is most likely to benefit from Brexit? And here the overwhelming majority of the respondents said Paris, 70%. In second place, Geneva with 22%, but if you add to Geneva, Zurich and other Swiss fora, I think it was more than 30%. So Geneva in a strong second position. And I think this is also consistent with what Daniel told us about the efforts of Paris to also attract a larger part of the international litigation business that is currently heard in London. Now, moving on to my second topic, intra and extra EU bilateral investment treaties post-Brexit. As I'm sure most of you will know, the Lisbon Treaty gave the European Union exclusive competence to enter into investment agreements with third countries. At this point, I think there are more than 1,400 such treaties entered into by European member states with third countries. What the Lisbon Treaty didn't determine was the fate of these treaties pending the conclusion of treaties by the European Union. So once, for example, the European Union will enter into a investment agreement with, say, Morocco, all of the bilateral investment treaties between EU member states and Morocco will be superseded by that treaty. But in the meantime, the destiny of these treaties is determined by the Regulation 12/19/2012. And that regulation says that until there is such treaty, the existing bilateral investment treaties between the European Union member states and the third states will remain in place. The European member states are obliged to notify the European Commission of the existence of such treaties, and the European Commission will then determine whether there are any problems with these treaties and may direct the EU member states to take appropriate measures if there are such problems. But other than that, these treaties remain in place. If a EU member state wants to modify an existing treaty with a third state or wants to enter into a new treaty, it can only do so with the agreement of the European Union. So what's going to happen post-Brexit? It depends, of course, whether the UK will agree to continue to apply this regulation. On the one hand, this would be consistent with this withdrawal bill, which said that the acquis communautaire should be transferred into UK law. On the other hand, of course, it would be completely contrary to everything that Brexit stands for, i.e. the freedom of the UK to enter into new trade agreements with third states, etc. So I think it's extremely unlikely. It's much more likely that post-Brexit, the UK will be able to enter into such treaties in a completely unfettered fashion, and that the old treaties that the UK entered into independently will remain into force. What's going to happen to the treaties entered into by the European Union? Again, I believe it's more likely that they will quickly be superseded by bilateral investment treaties between the UK and such third states. Perhaps more interesting than extra bilateral investment treaties are, in particular at this moment in time, the intra-EU bilateral investment treaties. Now, as I'm sure you know well, the position of the European Commission has traditionally been extremely hostile towards such treaties, and as early as in 2006, it directed the European member states to terminate such intra-EU bilateral investment treaties. So just to explain, intra-EU bilateral investment treaties are bilateral investment treaties entered into between EU member states themselves. And there have been actually a large number of claims brought by international investors against other EU member states under such treaties. And just by way of example, I'm sure you have heard of the numerous claims brought by investors against the Kingdom of Spain, arising of certain modifications to its system of subsidies to renewable energy. So there are I don't know how many claims in total. The kingdom is currently subject to 40 investment treaty arbitration claims, and a large number of those are being brought under these intra-EU bilateral investment treaties. So, for example, a German investor suing the Kingdom of Spain under this treaty rather than going to the Spanish courts where the hopes of getting meaningful relief may be not as well-founded as in an international arbitration. Now, going back to my slide, European Commission extremely hostile towards such treaties, directed the EU member states to terminate them. Only a few member states complied. It then brought, I think, 4 or 5 legal actions against against member states because of their non-termination of such treaties. And then, from a legal perspective, fascinatingly, it also ordered Romania not to comply with an arbitral award rendered under the Dutch-Romania bilateral investment treaty. In that case, the issue was whether certain aids granted by the Romanian state prior to the accession constituted illegal state aid under the EU regime. And the arbitral tribunal said that the revocation of such benefits constituted a violation of the bilateral investment treaty and therefore granted compensation to the foreign investor. The European Commission then said, which had been of the view that the initial granting of these benefits was illegal state aid, said that the payment of compensation would be akin to a reinstatement of the state aid that had been revoked by the Romanian state and would therefore be in itself illegal state aid. And therefore it then ordered Romania not to comply with the arbitral award, because doing so would again amount to granting illegal state aid to the investors. So that was the clash of jurisdictions. The investment tribunal telling Romania, on the one hand, you need to pay the investor money, and the European Commission telling Romania, if you do so, you violate European law. There's currently a case in the European courts pending in which this issue is being determined, because the investors have challenged the European Commission's decision ordering Romania not to comply with the award. And then, of course, and the Achmea judgment, which Danny has already mentioned, which very recently, a couple of months ago, so held that arbitration agreements contained in investment agreements, for example, in bilateral investment treaties, that give independent arbitral tribunals the power to interpret and rule upon EU law, are a violation of European law and therefore invalid. And therefore, there's now a huge question mark whether investors are still able to bring or successfully bring actions in under bilateral investment treaties in an intra-EU context. So that's the where we currently are in terms of inter-EU bilateral investment treaties. So what does that mean for the UK? And with all this negativity about Brexit, I think in this regard, Brexit is actually an opportunity for the UK for several reasons. First of all, in terms of the, my first point is here the skepticism of the EU towards international arbitration in trade agreements in general. I think being able to conclude investment agreements independently will allow the UK to enter into such agreements and provide for effective international arbitration dispute resolution mechanisms. Secondly, given this huge doubt as to whether intra-EU BITs can still be effectively used by investors, I think there's a real chance for the UK to become a kind of passport jurisdiction through which investors in European countries may channel their investment so as to be able to rely on the protection granted by bilateral investment treaties. So in America, for example, let's say a Chinese investor may, rather than invest directly in Germany may channel the investment through the UK so as to be able to benefit from the protection granted by a future treaty between the UK and the European Union. The Achmea judgment may also open up new opportunities, because if you read the rationale of the judgment, i.e. the skepticism of the European Court that arbitrators are able to rule upon European law without the courts ultimately being able to properly review the findings of the arbitral tribunal, this rationale actually applies almost one-to-one to commercial arbitration. In this Achmea case, it was actually an UNCITRAL case, which was subject to review by the German courts, and the German courts, of course, have a public policy exception, which allows them to not to enforce or to annul an award if there's a violation of European Union law. Now, that's exactly the same test that applies to commercial arbitration awards in case of an alleged violation of European law. So the rationale is actually, or it's at least to my mind, impossible to distinguish from commercial arbitration. So it may.
They say it's very different. They say it's very different.
But it's yeah.
Yeah, I agree with you.
Yeah.
But they say in that same judgment it's very different.
I know, but the reasons, the reasoning cannot be distinguished. I don't think. So,
I agree.
If this is only a precursor to perhaps more hostile arbitration decisions coming out in the future, again, it may be a chance for the UK to establish itself as a bastion of arbitration. And then my very last point is that there's also talk about whether the act of Brexit itself could be considered as a violation of the fair and equitable treatment standard under that is afforded by many bilateral investment treaties, or even an expropriation. So, for example, if the UK government makes certain or gives certain assurances to was it Nissan, this car factory, and then later on, as a result of Brexit, no longer complies with these assurances, could this then give rise to a treaty claim against the UK? So that's also a risk that the UK government, first and foremost, needs to bear in mind when conducting these negotiations and agreeing upon potential solutions. And that concludes my presentation. Thank you very much indeed.
Thank you very much, Janice. I don't know if you have questions or contributions that I want to make to the discussion before we go for a coffee break. Is there anybody who wants to say?
I'm just going to repeat something Anna said, but I think the Achmea decision will actually have a beneficial effect on the UK as an arbitration situs. And that survey you mentioned was actually conducted before the Achmea decision came out. And frankly, it will still take a number of months before it starts seeping into people's consciousness, but it's a reason. One other question sort of on the opposite side, though, is I have heard from corporate counsel more in Europe than in the UK, but London is viewed as a more expensive arbitration situs than Paris or Geneva, or frankly even New York, given the propensity of New York firms to negotiate rates and deals. As essentially European lawyers acting in London, do you have any comments on that?
London is expensive, but as Daniel said, you get what you pay for. Right, so I think the quality here is extremely high, and this is why sophisticated users are happy to pay more for London arbitration. One factor, obviously, is this that many solicitor firms use barristers, which then adds a huge amount to the ultimate bill, and yeah. But this is, as I said, this is part and parcel of London arbitration in my book.
Just a couple of observations on what Daniel was talking about in relation to the current Rome regime for choice of law and the Brussels regime for jurisdiction. Of course, the Rome 1 and Rome 2 regime will be quite easy to replicate post-Brexit because it doesn't rely on any reciprocity among the member states. It's simply a harmonized system of rules. It doesn't matter whether the choice is on a member state's law or some other law. So for the existing member states, it'll be business as usual, and for the UK, the intention is to incorporate Rome 1, Rome 2 to domestic law, so it will also be business as usual. Of course, jurisdiction much more complicated, as we said, because that does rely on reciprocity. But the new music from what the government position papers have said and all the reports you've read is reasonably positive. There will be, I think, some sort of solution, whether it's Lugano, whether it's some sort of agreement to adopt Brussels along the lines of what Denmark has done. And there seems to be a degree of consensus between the EU and the UK as far as the transition period is concerned. It's sort of all up in the air. So I think it's obviously not top priority for Brexiters, and that they may not care too much. And so hopefully sensible people will put their heads together and come up with a sensible solution to rather preserve the status quo.
Any more questions or contributions?
So now I would request Mr. Rotimi Sani to present the memento to our speakers. Thank you. It was indeed very nice presentation.
Brexit.